There is also a perception or widespread opinion that whenever people from the scheduled caste, scheduled tribe, or the marginalized sections come into prominence, when they come into positions of power, or even like as ministers or officials, whatever, there are immediately, there is some kind of vigilance inquiry against them. They become the target of various kinds of accusations, allegations, and all. And a lot of people have been saying that, yeah, Justice Karnan is another example of that. Like, look here is a scheduled caste judge, and now look at all the. So, have there been such earlier instances in the judiciary where people from Dalit or backward caste backgrounds have been kind of targeted or have been?
I was a very junior lawyer when I happened to be a post of Justice Dr. K. Ramaswamy, who was a very prominent judge of the Supreme Court, and who was having the record of passing of highest number of reported judgments.
Okay.
He was, and that record I think was there for a long time, and so I have invited him for one of my program in Pune. So all my friends were not from either fraternity. So they said, now you have to look after the judge because you are the lawyer. So because whatever he will discuss something about the justice, judicial system, and something like about the bar and bench. So I said, okay, it was in Circuit House of Pune, and then I was sitting with him for 2 days. I was, whole day he will tell me something. I think there was a autobiography by him also. And before that was published, he told me every story of the biography. Okay, so he told me that he was a very prominent judge of the Andhra Pradesh High Court. But when he was supposed to be made as a Chief Justice, he was being made as a Chief Justice of Sikkim.
Okay.
Now Sikkim has one Chief Justice and one judge. That is the strength of the Sikkim.
Two members.
Two members. And 1 or 2 cases will be filed in 1 or 2 months. So you do not have absolutely any work in Sikkim. So don't you think that this is some kind of a institutional to utilize on the basis of caste system? Second argument is when Justice K.G. Balakrishnan, and he was supposed to be elected to this, but he was not elected for many times, and he was superseded by many. They became the Chief Justice also. He was superseded by juniors. And he was not being elected. He was only elected because of the intervention of His Excellency, the President of India at that time, Dr. K. Ramaswamy. Look at it, means this is how, and then, Justice Ramaswamy also told me that he was also superseded.
I see.
But it is because P.C.U. Shankar came, who became the law minister, and it is because of his intervention he became the judge of the school. Then he told me one incident on the bench also. And it was one constitution bench hearing the case regarding Article 341, 342 that pertains to the identification of SCSTs. He told me that, yes, he did not tell me the story of discrimination, but he said they have one-sided perception. The other members were having one-sided perception. I am not going to tell the case name of the case. I am not going to tell the name of the Chief Justice because that is something which I don't want to go into. and even Justice Ramaswamy will not permit me for this. But he said, and I think he concurred with me, he agreed with the majority judgment. Means it's a unanimous judgment, basically. He participated. But he says he still have a dissenting judgment lying in his house.
I see.
Yes. So, what does it tell you? It is something very serious. So, my opinion, when the UK says that without a diversity you cannot ensure that the justice is done, because when the different people from different background comes on the bench, they bring different understanding, different perception of understanding the concept of justice, and they ensure the justice.
So that brings.
Why India is not coming to that?
No. So if you are taking the appointment of judges, then the collegiate system versus the NGAC, the Judicial Appointment Commission. So, like, would you then favor a Judicial Appointment Commission rather than the collegiate system?
I have taken a stand on this, and it was long back. I delivered my first speech on this. I think it was in 2007. Look, you see, there was a case of 1981 SP, which held that consultation with the Chief Justice and the opinion of the Chief Justice is not binding on the President. And the executive government of the country is free to appoint a judge to the Supreme Court or the High Court. On its own, without any such kind of concurrence or some kind of that understanding between the Chief Justice and the executive government. Thereafter, somewhere 87, 88, 89, during that period, late 90s, you can say, there were two law ministers, B. Shankaranan and P. Sushan. They appointed dozen judges to the Supreme Court, and none of them was Brahmin.
Yes.
And during that time only you would find the judiciary was most efficient.
I see.
Means there was a least pendency in Supreme Court. That time the equal number of cases as compared to today, the equal number of cases were filed in Supreme Court. And there was no pendency because during that time you were Supreme Court. During that time only you got a women judge to the Supreme Court. Fatima. Then you got a Ramaswamy, Justice Ramaswamy from the Scheduled Caste background, and then Nawal Panchayyan and Justice Reddy, then P.B. Sarma, Justice P.B. Sarma. They were all judges of that batch during that time period. And because of that, almost it was like almost the Brahmins percentage was absolutely negligible. But Chief Justice, during that time, I think the Chief Justice was there, Rangnath Mishra was the Chief Justice. And Subhash Sharma was the advocate of the Supreme Court. Filed a case in the Supreme Court for filling of vacancy of judges in various courts. And Chief Justice Rangnath Mishra with other two judges, means that was a bench of 3 judges. they doubted the correctness of SP Gupta.
So this is the second judge's case, right?
Yeah, SP Gupta is the first.
First one.
And this SEO are coming to that. So in Subhash Sharma, Chief Justice Ranghunath Mishra's bench doubted the correctness of the SP Gupta that was delivered by 7 judges bench. So 3 judges bench doubted the correctness of 7 judges bench and referred the matter to the larger bench. So that is how the 9 judges bench of Advocate on Records, Supreme Court Advocate on Records of 93 was constituted. And judgment was delivered in 93. It was 6 October 1993, I think. And you see, they held. I think that is mostly against the principle of the Constitution.
Yes.
If you go through the minute reading of the Constituent Assembly debates, so that proposition which they have laid down has already given a veto power to the Chief Justice, which was denied to the Chief Justice by the Constituent Assembly. And they said it was by it means the concurrence or the consultation is mandatory and concurrence, and absolutely giving power of appointment to the they held absolutely giving power to the collegiate.
Consultation is read as concurrence.
Concurrence. I think it is beyond concurrence. You are bound to accept it. It is not even a concurrence. If it is referred back once again, if it is sent to the government and if it is written and if it is once again sent, the government is bound to do it. So it is absolutely giving a power of appointment to the Chief Justice and other 2 judges. And that was further expanded by 1998 judgment of 9 other judges, making it a 5 judges college. Chief Justice plus 4 signatures. And the 6th is a Chief Justice to be, if he is going to be Chief Justice in future, then he will be also income.
Oh, okay.
So, see, that proposition, okay. Why I am telling you? It is my analysis. The SC Advocate on Record, Supreme Court Advocate on Record 1993 judgment, gave a veto power to the Supreme Court's collegium, gave an absolute power to appoint a Supreme Court and High Court judge. Is basically because the upper caste judges were their strength was coming down in the Supreme Court, maybe in various high courts. I am not having the statistics of various high courts, but yes, that could be. And thereafter, Venkatachala, Chief Justice, he became the Chief Justice, and he appointed 7 judges. And during that time, the strength of Supreme Court judges from 1812 to 25. So he appointed 7 judges to the Supreme Court, and 6 were one caste. So from that whole historical interpretation, I feel that the more recent judgment in SP Gupta was turned down or overruled only to ensure the single caste composition in Supreme Court, and that is something very casteist, very against the Constitution, very against the democracy. That is resulting into the exclusion of SC/STs in the Supreme Court.
Yeah, so then from such a system, I think we can only expect that the lone crusaders become rebels then, right?
Yeah, so see, in such kind of system that, one judge is nothing, one judge means if you are a judge of a high court, I tell you, junior judge. You do not have absolutely what power you have because you will be sitting as a junior judge. You may be given an assignment of uninteresting subject or of some subject of old cases. There are thousands of cases pending, lakhs of cases pending. So you are told to finish all those phases. So absolutely you will be very, very troubled and you will feel that you are being excluded, you are being discriminated, and if that feeling is exaggerated in some person, then of course that will come out one or the other day, and that must have happened with Justice Karnan, I feel.